Your Honors, Frederick O'Neill on behalf of the appellants Arthur Peach et al. And I'd like to reserve 3 minutes.
3 minutes, okay.
This is an appeal by a group of intervener plaintiffs from an order dismissing their complaint for declaratory relief under Section 712.12 as untimely. 2.5 years prior to the dismissal, this court decided.
I mean, there's no dispute that the interveners sought to intervene after the deadline, correct?
Not a
It's
dispute.
all a question of whether their intervention relates back, right?
Bingo. Yes, Your
There's
Honor.
also no question that they had separate individual parcels, and some of them were in units or phases separate and apart from the original plaintiffs.
Correct.
Is that correct?
Correct.
So being individual parcels and being in different units, help me how this relates back.
Oh, well, are we talking about the case this court decided or talking about the original plaintiffs?
This case.
The original plaintiffs. The arguments that we've made in our briefs is that when you have a class, well, let me back up. We would assert it's not a relation back question. It's a question of statutory interpretation.
Let's look at the statute.
Yes.
The Marketable Record Type. The operative provisions, I think you will agree, are 7112.112, subsections 3 and 4. You agree with me on that? And this is a legislatively created sort of one-time blue light special. That one out of these encumbrances, you want to slip the noose from these restrictions, and you meet these other criteria, as long as you file, and this is, let's go to the statute, with respect to any parcel, blah, 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 the parcel owner may commence an action by October 1, 2019.
Right.
And then it goes on, and then we look at 4, and this is the part about not revitalizing. The covenants that don't apply to the rights of the parcel owner, which are recognized by any court order or judgment in any action, unless the parcel owner consents. And the common sense read of that is, and it's consistent with MARTA generally, right? That these are individual parcels, and as Judge Morris asked you, each of these parcels, they don't share commonality in the sense of relation back analysis. Like, I would liken this to the loss of consortium plaintiff who doesn't get to join the original negligence action. And, you know, I understand your arguments about likening this to a class, but I don't think that, you tell me where I missed this, I don't think that you would have a snowball chance and HE-level hockey sticks of getting a class certified with the differences between these units
Good comment.
and class.
Right.
So, going back to the statute, help me understand why the
Right.
legislature's careful
Let's
use
just-
of any parcel.
Yeah.
And how MARTA operates, which is to sometimes create a little bit of Swiss cheese in an HOA development.
Mm.
So help me understand, please.
Okay, I'm just going to set the whole class argument to the side because I don't think we need to prevail on that in order to prevail on the appeal. And the reason is because of the way subsection 4 was written, and then I'm going to look at another statute in chapter 712. Your Honor, you read that section of subsection 4, and I'm just going to go a little bit further, and it says, in any action commenced by October 1, 2019. That's written in the passive rather than the active. It doesn't say commenced by the parcel owner by October 1, 2019. Now, I'm going to argue that you can look at that and possibly read into it, well, what they meant to say was commenced by the parcel owner by October 1, 2019.
You know, the problem we have, though, we're stuck with what they said.
Right, and
I
I
think they should have said, not what we think they meant. We are absolutely stuck with what the language the legislature chose.
Yes.
You know, because we struggle with this all the time, as you might imagine. We read language and go, surely they meant this and not that.
Right.
We can't do that. You know, they're the legislative branch, they make the law, we're the judicial branch. We just have to figure out what it is they said, not what they meant, not what they tried to do, or not what we thought would be a better idea.
Yep. Now, the action below was commenced, albeit not by the interveners, was commenced by October 1, 2019, in dispute, undisputed.
And that's where we run into trouble with the text of this statute, because it talks about the parcel owner being allowed to commence the action before October 1 of 2019. Not the parcel owner and his friends and neighbors, the parcel owner. And it's not mandatory, but the permission is granted to the parcel owner, not the parcel owner and other people who might be similarly situated.
Well, you can read that in there. But no, I'm saying a liberal construction of this statute.
Well, I read your argument with interest on liberally construed MARTA. And while I agree that, I mean, it certainly couldn't dispute that the legislature said that it should be liberally construed, my view of that is that what the legislature intended to liberally construe were the substantive mechanisms by which the MARTA's provisions could be implemented for the purpose of the Marketable Record Title Act, not a procedural lenience for the timing of when someone could avail themselves of this. And I'd like you to address your opponent's argument, which is that if you construe this the way that you're advocating, the prejudice that's going to result is entirely inconsistent with the substantive policy of MARTA. So if you could address that.
Yeah, the substantive policy of MARTA in 712.10, excuse me, that it's to be liberally construed. Just briefly, it says this law, meaning MARTA, shall be liberally construed to effect the legislative purposes of simplifying and facilitating land title transactions by allowing persons to rely on the record title as described in 712.02, which is basically the 30-year look back, subject only to the limitations as appear in section 712.03. If you look at section 712.03, it's got a laundry list of like navigable waters, the claim of the state for navigable waters, the claim of the trustees of the Internal Improvement Fund, public utilities, people in possession of the property, people who've paid taxes for the last 3 years. But what it doesn't have an exception for restrictions that are revitalized pursuant to Chapter 720. So if you narrowly focus on just Chapter 712, and what are the purposes of Chapter 712? It's not to facilitate revitalization and expand that. It's to have property owners be able to rely on the 30 years of looking back and are there encumbrances, are there restrictions on them? So
And this statute was enacted in October 2018, and they gave a strict bar date of 1 year
right.
in which to bring those actions. There's no wiggle room as far as when that was brought.
And I know you might think I'm parsing, but this action was commenced within 1 year.
Well, it was commenced by the original plaintiff, not by the
And you
intervener.
seem to rely on Bay Park Towers versus H.J. Ross, which is a statute of limitations type case for
Right.
the relation back argument. So help me, I mean, statute of limitations are here in Chapter 95, they're all detailed and enumerated, and
Right.
this one is not there. So
Right.
instead, we have a legislatively created deadline.
Right.
And as we talked about, each of these are individual cases, and we know that real property, the basic concept of real property law is every piece of property is unique. They're not fungible, even platted lots in a subdivision, the law tells us are not fungible. So because they're each unique, the subject matter of these intervenor lawsuits are all different than the lawsuits that have previously been filed.
To an extent. I think there is commonality in the sense that it's the same restrictions. All these parties, the original plaintiffs, the intervenor plaintiffs, the association's members, They're all party to the same contract, which is the declaration that created.
But the
Did you make this argument in the
Oh,
trial, I'm sorry,
okay.
was this argument made in the trial court about that they're all parties to the original restrictions and that the
I believe it was, Your Honor.
names are mutual across all of the properties?
I believe it very much was, Your Honor. I filed it.
So, I didn't see it in the record below, but let's assume that it's sufficiently preserved. What do the mutual easements and so on have to do with Marta?
Well, with the easements per the plat have nothing to do with MARTA, because those are outside MARTA, can't be extinguished by MARTA. But the commonality, if we're talking about in the context of a class situation where there's intervention by an unnamed class member into the class, when we're talking about that, the commonality is important. And with the idea that this is the same declaration, all these people are parties to the same declaration. The declaration is the document that creates these restrictions. To say they don't have an interest would be, I think, pushing it too far in the other direction. They do have an
They
interest.
they may have a commonality of interest in the restrictions, but they themselves, and I think this is even included in the second amendment complaint in the allegations, they have a different complaint with respect to what their deprivation of those rights are, okay? And I think some of those are examples that were given in the pleadings, which are, they could have a mortgage, they could have a title insurance issue that may be brought up. And those are things in the complaint that they themselves lend to the fact that these aren't common issues that necessarily would go across
Right.
all of the plaintiffs.
Totally agree. It's not 100% common, but there is to an extent a commonality.
What is the commonality besides the fact that they all own property within Miyaka Valley?
The commonality is that what we're talking about are the same restrictions for all these people.
But don't they differ in time based on where the unit is, the unit on the plat?
They do, and that applies also to the original plaintiffs. The original plaintiffs are spread over the 5 subdivisions as well.
But they brought their claims timely.
They brought their claims timely, and this is my key argument, and if you disagree, then I could probably sit down. My key argument is that you can read subsection 4 in the passive, that someone can seek this kind of relief in any action commenced by October 1, 2019.
Well, we have to read the whole sentence, which talks about the
Right.
rights of the parcel owner, which are recognized when action commenced.
And I don't think any of that contradicts.
It talks about getting the consent of the affected parcel owner.
Well-
The affected parcel owner. So how does that work with this sort of quasi-class commonality analysis?
Well, Your Honor, the part that you read in the statute, I'll just reread it. They do not apply, meaning the revitalized restrictions do not apply or affect the rights of the parcel owner which are recognized by any court order or judgment in any action commenced by October 1, 2019. And under our reading, that passive way that it's written, that if there's an action that's timely filed, if we can intervene and assert our own claims, then we can fall under the protection of subsection 4. Now, I know that's neither fish or fowl. Sorry.
A claim that is tied in a more specific way than just we live in the same neighborhood to the original plaintiff's claim.
Well, that's
To intervene
getting,
and prosecute.
right. You're right, but that's getting into the propriety of whether they should have been allowed to intervene in the first place.
So that wasn't a reviewable decision until the trial judge dismissed their claims, right?
True. And Your Honors could go back and say that the trial judge erred by allowing to intervene in this action, because the trial judge at the time of the motion to intervene had before it the second amended complaint that had all these additional parcels, that involved the intervening plaintiffs, but the trial judge allowed it. There was no objection to, if at this point they raised the objection to the trial judge granting the motion to intervene, I'd say, well, that objection's long gone, kind of a thing. So I guess
The intervention doesn't guarantee you the right to participate, not to be dismissed, not to suffer an adverse judgment.
Right.
It just means you're there to at least flesh out what your claims are through the dismissal stage at minimum.
yeah, but again,
You're at 15 minutes, sir, just so you know, but it's your time. You can use it any way you want.
well, yeah, I would like to keep going. You brought up the Bay Park case, the Bay Park condo towers case. That cited law from, I guess, American jurisprudence or something like that. Just the general rule that when you do have an intervention, for statute of limitations purposes, it relates back to the original complaint that was filed by other people. And basically, that's the argument that we're facing here. We just want to relate back and get the relief that 712.12 sub 4 allows a parcel owner in any action commenced prior to October 1, 2019. Thank you, Your Honor.
Thank you. You'll have 4.5 minutes when you return.
Thank you.
Good morning, Jim Burgess on behalf of the LA Myakka Valley Ranches Improvement Association. First, I want to apologize for misquoting or misstating some statutes. My opposing counsel pointed out I used 712 instead of 720.403 to 407. Sorry, I really, it's kind of embarrassing, and I'm sorry that occurred. Basically, I agree with Your Honors that the first thing you have to do is look at the statute. What does it say? And I think your comments were very succinct, and it's very clear what it says. It says, here's what you have to do to keep.
But those things were when we were asking him questions.
Right.
Now we're asking you questions.
No, that's true.
That's devil's advocate questions. Nobody gets off easy here. So here's the thing, it is
Okay.
troublesome that all these people live in Myakka Valley. All of them are faced with these deed restrictions, which have expired. How are there cases, I mean, you heard me make the case about real property being, every lot's different, but on the other hand, this legal issue is the same for every single one of them. So why is it, I mean, why can't they intervene? Why doesn't it relate back? Because it's the same issue. The deed restrictions have expired.
Well, one, the statute says the parcel owner has to bring it. That's my first response. Second is,
But they're interveners. Someone did bring it.
Someone did bring it.
The same issue with the same deed restriction in the same subdivision, and they just tried to, come in and join them. And we have the Bay Park Towers case. We have other cases. We have the rule of civil procedure 1.190 that would say that basically when a claim or defense rose out of the conduct set forth in the original pleading, the amendment should relate back. Now I think that deals with another cause of action. That rule doesn't deal with intervener plaintiffs. But why shouldn't it relate back?
each property owner, it's unique to them. It is, do they want to be part of the deed restrictions or not? Do they want to be revitalized? They have to make that decision. It's their property. Property owner 4 has no interest in whether property owner 1 decides they want
The
to.
additional ones do want to be, so everything you're saying is true. All the additional ones, they want to be a part of that.
They do, but they didn't timely file their claim under the statute.
I mean, if nobody in the subdivision had filed a claim, I would say, you're out of here. I don't even know why you're here. But you've got some of them that did.
Right.
On the same basis that the ones that came after the fact say, hey, we want to take advantage of this too. And yeah, we missed the deadline, but they made the deadline and our issue is identical to their issue. Why can't we have ours decided along with it?
Well, their issue isn't identical, other than that they don't want to be subject to a revitalization. Every one of those property owners are in different units that were recorded at different times. For example,
But it's the same deed restriction.
no, it's not even that, because, for example, they had just attempted to revitalize the restrictions, at least as to several parcels out there, I think parcel 2 and 3. They had to use old restrictions because the ones that were amended in 2008 weren't any good because the MRTA had extinguished them before that date. And there are units out there, units 4 and 5, that would be subject to the 2008 restrictions, which are different than the prior restrictions. It's not even the same there. For what that's worth, it's not in the record, but that's what's occurring out
So
there.
let me ask you a question. and I asked your opponent about this, why couldn't why couldn't a plaintiff bring these claims as a putative class plaintiff? And tell me why not, and assume that I don't agree with you.
Okay.
And why then shouldn't these unit owners be able to join under essentially a class theory, which is sort of what I think, part of what your opponent is arguing?
Well, first, let me say this. I'm not a class action specialist, but I know it is very difficult to get a class certified. And I don't know all the ins and outs of that. But in this case, every one of those unit owners is in a different position, potentially. And to somehow say you're going to create a class, I don't know how you could do it.
And part of what I'm asking you for is there any way to interpret or non-interpret subsections 3 and 4 when it says any parcel, with respect to any parcel owner may commence? Why couldn't that parcel owner be the, Joe Smith on behalf of all other Myakka Valley unit owners similarly situated?
Well, it wasn't done that way, first off. But second, like I said, I'm not an expert on it, but I think it'd be very difficult to get that class certified with different restrictions applying to different sections.
So your argument on units 4 and 5 having different temporal affects of when these restrictions were recorded and could be revitalized would be one of your arguments.
One of the arguments.
Commonality and typicality.
And again, I like to go back to the statute. It doesn't say any parcel owner may commence. It says the parcel owner may commence an action by October 1. And these parcel owners that sought to intervene did not do that. They have to rely on somehow relating their claim back to the original pleading, or they don't meet the requirement of the statute. And I've cited the court to several cases, and I don't know that I need to go through them with you, but you talked about the consortium claim, like Phyllis Morris versus McCall. The rule is that this relation back doesn't generally apply when the new claim is a separate and freestanding claim belonging solely to the party intervening. Okay? The consortium claim arose out of the accident. Okay? That's the operative facts. But that claim is a separate, distinct claim owned by the spouse that had to be brought within the 4-year statute of limitation. Those are the kind of cases that I think are applicable, not class action things or an association seeking to intervene in a plumbing.
Park where you've got
Right.
an engineering that affects the common elements.
Right.
Your best case of the three, you've got a trio of them, Philip Morris, Rayner, and Russ. Which is your best case?
Well, I don't know that I can tell you which one. Russ versus Williams added the wife of the original defendant, who was the actual driver of the vehicle. Even though they'd sued and had the right facts and this occurred, they didn't bring her in until after the statute of limitations had run. It's a separate claim against her. It's the Rayner aircraft tried to add a new party defendant, and the statute of limitations had run. Even though the operative facts about what caused the claim was in the original complaint, you added a new party. And you added, so you had to go back and meet the original statute of limitations. Had this case been brought as a class action, there would have been a lot of other things that would have been argued. It was not. And I just go back to the simplicity of the statute. It says that the parcel owner may commence, not any parcel owner. The parcel owner or anyone on his behalf or similarly situated. It doesn't say, it just says the parcel owner. And I think that goes back to your point that real property is unique. Every real property is unique. And there are a lot of people out there that want deed restrictions. They don't mind if they get revitalized. It's their decision.
I'm going to ask you this question largely for your opponent's rebuttal. The declaration that you're going to try to get if you are traveling under the statute is that the restrictions didn't govern that parcel as of October 1, 2018. And that may be one of the problems here because of the different temporal issues associated with the different, I don't know, call them units.
Absolutely.
Am I wrong about that?
You're absolutely right. You're absolutely right. They got dedicated at different dates along the time spectrum, with 1, 2, and 3 being earlier than 4 and 5. And so,
Paraphrasing where you're coming from, and again, for the benefit of your opponent, in looking at Rayner, I think, that creates a problem with identity of interest, doesn't it?
yes, it does. It does. And I absolutely agree. There is a reason the legislature made the statute the way they did and wrote it the way they did. As I misstated, but 720 point, let me just do this. When MRTA was initially enacted, an unanticipated consequence of it was getting rid of deed restrictions. And so we had a series of changes in the statutes that allowed preservations, that allowed revitalizations, that all occurred. And the new statute, or the 720.403, says very clearly that homeowners are encouraged to preserve existing residential communities, et cetera, by the revival of a previously declaration of covenants and other governing documents that may have ceased to govern some or all of the community, all parcels in the community. That is very consistent with Chapter 712 in MRTA. MRTA is designed to, you don't want somebody to be able to make some stale claim to title. The deed restrictions are something a little bit different. They are things that run with the land that do horrible things, like say you can't have a pink and purple house, or your fence can only be so high, or you can't park 3 motorhomes out in your front yard. Those are not things that affect somebody's title. They affect the use a little bit, but they not affect their title.
Were these objections, as far as the time period, were they raised at the motion to intervene?
Yes, and if you'll review the transcript, the judge did not want to hear it. She said, go ahead, I'm going to allow him to do it, you make your
She
ruling.
anticipated a motion to dismiss it.
Correct.
Okay.
Correct. So that's why we ended up in front of the on the motion to dismiss, yes. That, and that happens. I tried to make sure I didn't waive anything by just allowing the amendment itself. And then when she said to do that, we went ahead and filed our motion to dismiss, and it was granted. So if there are no other questions, I'll be happy to sit down.
Thank you, sir.
Thank you very much.
You have 4.5 minutes.
Your Honor, commonality seems to be the key issue here. In 5 different subdivisions, 5 separate sets of restrictions, 3 pretty much the same, but nevertheless, we will concede they were recorded separately. Where's the commonality? Good question. If you read through the complaint, in 2004, the association filed 1 notice of preservation under MARTA. And that 1 notice of preservation was to as all 5 units and the restrictions on all 5 units. At the time, they felt that there was a commonality. On the question of commonality, I think legal issues, and I think Your Honor pointed out, I think the legal issues are pretty much the same. There were, in the original plaintiffs, there was somebody from each of the 5 units. And so the legal issues.
So let me ask you a question. Are they pretty much the same, or are they exactly the same?
They're exactly the same.
Okay.
The question is whether they ceased as of October 1, 2018, according to the statute, the way statute. Factually, we'll concede there's this parcel, there's this parcel, there's this parcel, and there might be questions in the title and things like that. But I would submit that in just about every class action, there are factual distinctions between whether it's plaintiffs or defendants. In the Litvak case that we cited to the court for the purpose of saying that where there's a class and somebody intervenes, it relates back, that was a suit against a property insurance company. Nobody's going to tell me that the claim for, Mrs. Smith over here for her house is exactly the same as the claim by Mr. Jones over here for his house. There's factual distinctions, but the common questions, the important common questions for the court to consider are the legal questions. And the legal questions are the same. They were raised, all the different restrictions were attached as exhibits to the complaint, and they were attacked in the sense we said, as of October 1, 2018, they were extinguished. The question about whether revitalization would deprive the clients of constitutional rights, that's the same legal issue, whether it's the original plaintiffs or the intermediate plaintiffs or something like that. The real burden, I don't know that this is important, but the real burden of defending this lawsuit is the same. If you allow the interveners in, the burden is the same. They have to face the same arguments and win the same arguments. It's a bad argument to make that, let's start with a conclusion and work back from there.
So if we accept this argument, then basically, how far down the road can an additional plaintiff be added?
Well, I think at that point, it's a question of whether the intervention would be proper. And the court has to take a look at the facts of the particular intervener and the status of the case. I think it's not set for trial.
Follow her question with sort of a nuance. Have all the people that live in Mayaca Valley Ranches at this point endeavored to file a claim?
Your Honor, I've talked to, I think, 3 additional homeowners who
Who have not yet done it?
not happened. No, of course, this will obviously be key to whether or not they can.
Okay.
And I could see that the court could adopt some kind of a reasonable interpretation that says, yes, it's written in the passive and it says in any action filed prior to October 1, but reasonably speaking, if it's not filed within so many years, intervention should be denied or
So,
something.
but you're suggesting we can be legislators and we can't.
Well, I heard sort of a funny comment. It was that some legislators are frustrated judges and some judges are frustrated legislators.
We're not allowed to be that anymore.
Yeah. No, I'm not accusing anybody on this bit, but. All right, thank you, Your Honor.
Thank you all. You all did a great job with a very interesting case. We don't see a MARTA case like this very often, but I appreciate your hard work and you helped us understand it better.
Thank you, Your Honor.
Have a good day, everyone. We're adjourned.
All rise.